The American Bar Association Rule of Law Initiative, in collaboration with the Institute for Human Rights and Development in Africa and Law Hub Gambia, have on Friday convened a dialogue on building strong rule of law institutions. On behalf of the Attorney General and Minister of Justice, Aliu Jallow says they need to look back and identify the obstacles that block the Gambia's constitution-making process.
In my view, the blame game should end. As professionals, we have met several times in sessions to share our thoughts on the draft constitution, and we could not agree on some of the provisions. All we did in most instances was to flag and without making any comments. That to me depicts a situation wherein a doctor could not conclusively diagnose and went ahead to prescribe medicine. The consequences could be fatal. That is exactly what happened in our constitution-making process. If we have to make headway, we must look at the issue from a holistic standpoint for the interests of the greater good.
Speaking on the theme, seizing momentum for constitutional change in the Gambia, Honorable Janet Ramatulai Salanjai says the 1997 Constitution was amended over 50 times by the former President Jammeh.
Believe it or not, when we were doing the review, we could tell that there were so many amendments, over 50 times, by the former dictator Yahya Jammeh. The formal process of reviewing the 1996 Constitution and drafting a new Constitution started in June 2018 with the appointment of 11 commissioners. On 30th March, the CRC submitted the final draft Constitution to the President. In line with the requirements in the 1997 Constitution, the Constitution Promulgation Bill was twice published in the Government Gazette, that is first on the 28th of May and then on the 28th of August. It was thereafter introduced into the National Assembly. This bill was tabled before the National Assembly on 14 September 2020. The draft Constitution introduced several measures aimed at enhancing and strengthening democracy and good governance. This included a presidential term limit, and I will repeat, this presidential term limit was actually prescribed by the Act establishing the Constitutional Review Commission, because we were actually entrusted with the responsibility of ensuring that there was a presidential term limit. Limits on executive power, which was very crucial because it was the executive power that led us to the situation that we found ourselves at the time.
She adds that women representation in the elective positions is extremely low.
Women's representation in the elective positions is significantly and extremely low, including the National Assembly. While the 2018 local government elections registered achievements with the election of the first female mayor in the country's capital and 2 of the 5 governors at the time in the country being women, the gender gap in the legislative and other decision-making bodies is evident. There is currently no constitutional provision that allows for special measures aimed at accelerating substantive equality between women and men. Yes, the laws are there for both women and men, but for women to move forward, bearing in mind the context that we find ourselves in, there is a need to have something to ensure that there is substantive and accelerated equality between men and women.
The dialogue aims to bring together transitional justice institutions, decision makers, experts, academics, researchers, media, and members of the civil society based on a recollection and forward-looking practical analysis to shape, discuss, and influence the course of actions and interventions on the constitutionalism, democracy, and the rule of law. For Kerr Fatou News, I am Fatou.